What legal cases define a hostile work environment? Imagine walking into your workplace and feeling uncomfortable every day. That's what a hostile work environment is all about. It's when harassment or discrimination makes the job unbearable. But what makes it legally serious? Let's find out. In the United States, the main law behind these cases is the Civil Rights Act of 1964. It stops discrimination based on race, sex, religion, and other protected traits. Over time, courts have set clear rules through important cases. These cases help define what counts as a hostile work environment. The first big case was Meritor Savings Bank versus Vinson in 1986. It was the first time the Supreme Court said sexual harassment creating a hostile environment is a form of sex discrimination. Before this, courts only looked at cases where someone lost their job or was demoted. This case changed that. The court said that even if someone doesn't lose their job, harassment that causes psychological harm can still be illegal. It also said unwelcome sexual advances or comments can create an unlawful environment if they are serious enough or happen often. Then came Burlington Industries versus Ellerth in 1998. This case explained how employers can be held responsible for harassment by their bosses. Even if the employee isn't fired or demoted, the employer can still be liable if they knew about the harassment and didn't do anything. The court said companies should have clear policies against harassment and ways to report it. This case made it clear that employers need to act to stop harassment before it gets worse. These cases tell us that to prove a hostile work environment, the victim must show the conduct was unwelcome, based on a protected trait, and severe or frequent enough to change the work conditions. They also need to show the employer knew or should have known about the harassment and didn't fix it. Other important cases expanded these ideas. Rogers versus EEO in 1971 recognized that racial discrimination can create a hostile environment, not just through firing or hiring but through a toxic atmosphere. More recently, Bostock versus Clayton County in 2020 extended protections to discrimination based on sexual orientation and gender identity. This means that harassment related to these traits can also be considered a hostile environment. In simple terms, these legal cases set the rules for what counts as a hostile work environment. They show that harassment doesn't need to cause economic harm to be illegal. Employers must take steps to prevent and address harassment. If someone feels they are in a hostile environment, they should document incidents, report them, and if needed, file a complaint with the Equal Employment Opportunity Commission or a state agency. These rulings help protect workplace rights and keep jobs fair and safe for everyone.